Please be seated.
Okay. The third and final case for oral argument this morning is the State versus OSTBY and Olmsted. For the appellant, State of South Dakota, we have Mr. Eric Hankey and Assistant Attorney General Aaron Hankey, excuse me. And for the appellant, appellee OSTBY, we have Mr. Ellery Gray, an attorney from Rapid City, and we also have Mr. Robert Pascalucci representing appellee OLMSTED, also from Rapid City. With that, you may proceed, counsel. You have 20 minutes.
May it please the court, counsel. The circuit court erred when it suppressed the search warrant issued by Magistrate Judge Callahan. There was sufficient evidence contained in the affidavit submitted by Officer Jant to support a probable cause finding. And if this court were to find otherwise, the good faith exception still applies. On March 20th, 2019, Ariel Roberts was doing laundry in her apartment building's community laundry room. She needed to use the dryer, but Olmsted's clothes were in it. She went to apartment 15 where Olmsted was staying with OSTBY and asked him to remove his clothes. Olmsted came, removed his clothes. Miss Roberts watched him do this, and immediately after, she found what she believed to be methamphetamine in the dryer. She contacted law enforcement, and Officer Jant responded to the call. He came out, field tested the substance, which was presumptively positive for methamphetamine. Officer Jant and Lieutenant Mertens then went to apartment 15 to speak with Olmsted. They knocked on the door and told Olmsted who they were. They could hear movement inside the apartment. Fearful Olmsted was destroying evidence, they gained entry into the apartment to secure the premise and detain Mr. Olmsted. Officer Jant then applied for a search warrant, and Judge Callahan issued a search warrant for apartment 15, OSTBY's vehicle, and urine samples for both Olmsted and OSTBY. Based on the search, Olmsted was charged with the possession of controlled substance, and OSTBY was charged with ingestion of a controlled substance. At the circuit court, Olmsted filed a motion to suppress, and OSTBY filed a joinder notice. After the suppression hearing, the circuit court issued its memorandum decision granting the motion to suppress. But the circuit court erred because there was sufficient probable cause submitted in Officer Jant's affidavit to find a probable cause finding for the search warrant. A suppression of the search warrant, when we suppress a search warrant, we're limited to the four corners of the affidavit. It must be looked at as a whole in a common sense manner. It is not to be viewed in a hyper-technical way. And it must contain a probability of criminal activity. This standard is somewhere between a mere suspicion and the trial court standard of beyond a reasonable doubt. There's not a specific formula or a neat set of rules for a probable cause finding. And the issuing magistrate must be given great deference into its probable cause decision.
So we had illegal substances, at least they field tested and had
Yes.
an illegal substance in the apartment building. What was the probable cause to the nexus to search apartment 15?
So there is a lot of information contained in the probable cause affidavit besides just the substance that Miss Roberts found in the dryer. Investigator Olson was working an active drug investigation on apartment 15. He had an unconfirmed tip that OSTBY was distributing drugs. In addition to Roberts' report of finding the methamphetamine in the dryer, she also reported finding meth in the hallway about a month prior to this incident, and she reported frequent short-term traffic to and from OSTBY's apartment, this apartment 15, and this information was also corroborated by Investigator Olson. He witnessed an individual go into the apartment for 2 minutes. He left his door open, his car running, and then left. And then this person.
Do we know from the affidavit if the officer observed this individual actually go in apartment 15 or just go into the building?
Go into the building, Your Honor.
Does the record reflect a time component as to when he made those observations?
It's not in the affidavit, Your Honor, but at the suppression hearing that did come out, that Officer Jant believed it was approximately March 5th of that year, which would have been about 2 months, or it's not 2 months, 2 weeks before the Roberts found the meth in the dryer.
But if we're looking at the validity of the warrant and the affidavit, can we rely upon later information?
No, Your Honor. We are confined to the four corners of the affidavit, and that's why I wanted to specify for you. It's in the record, but it wasn't presented to the magistrate judge.
To whom is the short-term traffic report sourced in the affidavit? It wasn't the reporting party, or it doesn't seem to have been. Who reported the short-term?
Roberts reported. Is that what you're talking about, Your Honor? Yep. Miss Roberts reported the frequent short-term traffic to apartment.
Right, it was. So,
It was Miss Roberts. Yep. No, that's fine.
apologize.
So we know from the hearing that Roberts lived in the apartment building.
Correct.
Do we know that from the affidavit?
I don't recall if it specifically mentioned in the affidavit that she lived there. I think that is a reasonable inference that the judge could have drawn. Issuing judges are allowed to draw reasonable inferences based on the affidavit. She was using the apartment's community laundry facility, so a reasonable inference would be that she did live in that apartment. So in the affidavit, law enforcement relied on information provided to them by Miss Roberts, this citizen. And law enforcement is allowed to use information provided to them by a third party. They're not confined to their own observations. But when assessing it, we have to look at the reliability of our informant or citizen, Miss Roberts. A known informant is considered more reliable than an unknown informant. And that's because a person who identifies themselves openly risks liability of accusing another of wrongdoing. In addition, giving an explicit and detailed description of the alleged wrongdoing that was observed firsthand gives the informant's information greater weight. And here, Miss Roberts is known. She's identified in the affidavit. There was no hiding her identity. In addition, she gave a detailed description of what she saw. She knew they were she knew they were Olmsted's clothes because she watched him take them from the dryer. She went to the apartment and asked him to remove them. And then immediately after he removed them, she found a substance that she believed to be methamphetamine. Law enforcement then corroborated that report by field testing the substance, which was presumptively positive for methamphetamine. So it's not like we just have, oh, I found meth, I think it might be his. We have a detailed description of what she saw.
However, we don't have any field tests from the prior, her allegation that there was a prior baggie of methamphetamine in the hallway.
That was not field tested, you are correct, Your Honor. However, when an informant is right about some things, we can assume she is right about others. She was correct about finding the meth in the dryer, and she was also correct in this short-term traffic to the apartment. So we can assume she was right. And that's just one piece of the affidavit. In looking at it in a whole common sense way, there was sufficient evidence in that affidavit to support the judge's
That was my question. Even if you're just curious about your thoughts, even if you took the trafficking or the distribution information or references out of the affidavit, and you were left with nothing more than a report by Roberts that somebody came out of apartment 15 in response to her request, took the clothes out, left a bag of a substance that later field tested positive for methamphetamine. Is that enough?
So if I'm understanding you correct, Your Honor, if we just had her finding the meth in the dryer and then the law enforcement tested
and
it.
Connects it to
Apartment
an
15?
individual in apartment 15.
I think it would be enough, Your Honor. With probable cause, it's a probability of criminal activity. It's not beyond a reasonable doubt. It's just, is it more probable than not that criminal activity is going on?
And I'm talking about the search, I'm not talking about an arrest.
No,
Just
yep, I understand.
Defendants seem to argue in their brief that the initial entry into the apartment was illegal. Is that significant to our analysis in this case, do you think?
I don't think it is, Your Honor. There is nothing in the affidavit, in the probable cause affidavit, of anything that was observed when they were entering the apartment. Law enforcement didn't say we found X, Y, and Z when we went in to detain
They
him.
observed Mr. Olmsted. They identified him. Sounds like the officer knew him.
Correct.
That was in the affidavit.
Correct.
There was a knife in the door, I think. That, other than opening the door, they wouldn't have discovered that.
Correct, Your Honor.
Is that any of that information significant to the?
I don't think it is, Your Honor. I mean, it certainly can be considered and viewed as a whole, but I think even taking that portion out of the affidavit, there was still sufficient probable cause for the circuit court, or for the magistrate court's findings. Now, the circuit court, in its decision to suppress the evidence, relied heavily on sharpfish, but this case is not sharpfish. Sharpfish is a case of consensual encounters based on an anonymous tip, and that is not what we have here. In its memorandum decision, the circuit court cited to Sharpfish and said, when law enforcement receives a tip, they must either personally observe the criminal activity or the tipster must have specialized training or knowledge of the alleged wrongdoing. And while that may be the case for a reasonable suspicion for a traffic stop, that is not the case for probable cause affidavits. And by erroneously relying on Sharpfish, the circuit court required the state to prove things or show things that it didn't necessarily need to show. It required that Ms. Roberts have specialized training or knowledge in detecting methamphetamine. It required law enforcement to personally observe criminal activity coming from apartment 15. It required law enforcement to be present when Ms. Roberts found the meth either in the hallway or the dryer. And it required law enforcement to observe a crime tied to apartment 15 when investigator Olson observed this short-term traffic to the apartment. So not only did the circuit court discredit this information, but I feel like he viewed it in isolation and took it piece by piece, and instead of viewing it as a whole, and if this affidavit as a whole contained probable cause. And while each piece of evidence it presented in the affidavit may not amount to probable cause, again, viewing it as a whole, it does. In fact, this court has upheld search warrants based on information provided at least in part on a tip where law enforcement did not personally observe criminal activity. They did so in Ravitz, Gilmore, Helland, Jackson, and Du Bois, just to name a few. In fact, the United States Supreme Court upheld a search warrant based on an anonymous tip in its landmark case, Illinois v. Gates. And here we don't have an anonymous tip. We have a known person, this person who lives in the building, who's seeing this activity, and she's reporting it to law enforcement. To look at this affidavit and say there is not probable cause is not drawing every reasonable inference possible from the from the affidavit. Now, this court recently looked at probable cause for a search warrant in Tenhold. Tenhold is different than this case, though. Excuse me. In Tenhold, you guys struck portions of the affidavit for reasons, and then what was left were two main components. Hotel security reported frequent short-term traffic to Tenhold's hotel room, and hotel security provided a list of casino patrons to law enforcement. And then they had this unidentified individual claimed he was solicited for money in exchange for sex or drugs from Tenhold's co-defendant. Excuse me. But and this court found there wasn't enough probable cause for a few reasons. One of them is there was no indication of illegal activity connected to the short-term traffic of the hotel room. And the people coming and going, there was no corroboration. There was no checking on the people coming and going from the hotel room and if they had any ties to the drug community. Here, we have not only Ms. Roberts reporting the heavy short-term traffic, but investigator Olson witnessed such short-term traffic when the individual went inside, left his car running with the door open, and left. This individual was later stopped and for a traffic violation and was charged with possession of methamphetamine. So we have some corroboration. Some of this short-term traffic is stemming from the apartment. Also, no one in Tenhold was able to say they saw Tenhold or his co-defendant with drugs. But here, Ms. Roberts found the methamphetamine immediately after immediately after Olmsted removed his clothing. So we have firsthand observation of someone witnessing Olmsted with the drugs. In addition, this court also found in Tenhold the solicitation incident was pretty lacking in details. There wasn't a name of the person who was solicited. There wasn't a time, date, or location. And so it was hard to have a time frame or to corroborate the information. And here, Robert's report of the finding meth in the hallway, it was given a timestamp. It was February 13th of 2019, approximately a month before she found the meth in the dryer. In addition, law enforcement was able to corroborate most other information provided by Roberts. This case is more akin to the Ravitz case. In Ravitz, a search warrant was obtained based on two unknown informants. One of the informants lived in the same apartment as Ravitz, and they reported frequent short-term traffic to the apartment. And along with the frequent short-term traffic, they also provided a list of license plate information, which law enforcement was able to run, and the names that generated from those vehicles, either some of them had prior drug convictions or they were known to law enforcement to be in the drug world. It came up either in briefings or other officers discussed them, like they have their eye on them. The second informant had experience in Ravitz, had experience in the drug community and could detect the odor of marijuana coming from the apartment. They also reported seeing a known dealer to that informant come to the apartment for a short time and then leave. So this case is very similar to Ravitz. We have someone who's living in the apartment, reporting this short-term traffic. She's reporting to finding meth in the hallway, in the dryer, and the information has been corroborated by law enforcement. So there's more than sufficient information in the affidavit to support the search warrant. And if this court were to find that the affidavit was lacking in probable cause, the good faith exception does apply here. Under the good faith exception, evidence may be admissible if law enforcement's reliance on the warrant was objectively reasonable. Suppression is only appropriate in 4 instances. When the issuing judge is misled by information in the warrant that law enforcement knew or should have known were false. The judge abandoned his judicial role completely. The affidavit was so lacking in probable cause, the belief that it contained probable cause is unreasonable. And finally, the warrant is so facially deficient that law enforcement can't reasonably presume it is valid. And here, none of those situations apply. There's been no claims made that any of these situations were present. And so it was objectively reasonable for law enforcement to find that the affidavit, or the search warrant, the search warrant was a valid search warrant. And so they were acting in accordance of such. If this court has any further questions?
I guess not. So thank you very much.
Thank you, Your Honor.
Mr. Gray, you have 10 minutes, sir.
Good morning, and thank you for your recognition, counselors. This morning we're here to talk about the application of law. We're not contesting the facts. We're not here to ask for new case law to be made, but we're here to affirm that we believe that the trial judge made the correct decision when he said the search warrant did not have enough facts to establish probable cause. This morning for organization, I'll be handling the first argument. Mr. Pascalucci has agreed to handle the good faith argument. For the benefit of our law students, we realize just because we're dividing it up, that does not mean that we are not suspect to answering other questions and other issues. But to really get to the heart of the probable cause issue, law enforcement shows up at the apartment. They look in the community dryer. They find the baggie. They test it, and it comes back positive, presumptively for methamphetamine. At this point, certainly it is true that there is probable cause that criminal activity is afoot. The question is, and the question as the circuit court defined it, is there a nexus or a connection to the criminal activity in the communal dryer going back to apartment 15 where the search warrant was ultimately executed? And to do that, we have to go back and I think do what the circuit court did and just look at the entirety of the probable cause affidavit. Now, as we look at that, I think it's important that, yes, we have to go through and talk about each piece. That does not mean that we're trying to engage in a divide and conquer analysis, but in order for us to evaluate what the circuit court looked at, to do a totality of the circumstances, we have to look at each circumstance. And initially, when you read that probable cause affidavit, there's a number of statements in there talking about other investigations going on. I think the officer even uses the word unconfirmed information that one of the defendants was engaged in distribution of methamphetamine. Okay. Ultimately, of course, the circuit court and the magistrate court, when it does its initial review, is looking as an objective gatekeeper. Their job is to look at the facts and to determine if probable cause exists. And to do that, of course, we have to look at the facts and not merely the conclusions or statements about other things going on. And I submit that when we look at those facts, they really fall into two categories. Those that Ms. Roberts tells us about, and those that law enforcement tell us about. Ms. Roberts tells us, we found a baggie here of suspected substance, and the guy from 15 had just pulled his clothes out. The officer does the field test. Now, the state in its brief, at least as I understood what their argument was on page 17, on page 15, towards the middle, I understood a concession that perhaps each piece of evidence was not enough to form probable cause, but be that as it may, it's our position that this alone, this piece of evidence, is not enough for a search warrant to get into apartment 15. There isn't that nexus to establish the entry because no one saw the occupant of 15 with the methamphetamine in his hand. They didn't see him and report him as being high. They said, we found a baggie in the communal dryer in the apartment.
But
What if
don't
there
we
was-
have to look,
Go ahead, please.
we have to look at the reasonable inferences as well. And,
Correct.
and in light of the fact that probable cause is a much lower hurdle, this isn't the trial. So why is that not a reasonable inference when the individual from apartment 15, contacted by the informant, goes and gets the clothes out of the dryer? Why isn't it reasonable to infer that that baggie had been in the clothes that ultimately came out of apartment 13?
So my answer would be this. That's a reasonable inference, but does that inference alone rise to the level of probable cause? And our position would be no, there should be additional information to establish probable cause as it relates to the nexus to get into apartment 15.
Well, the circuit court in resolving that question of was that sufficient nexus seemed to rely on the fact that law enforcement had to corroborate separately her statement that I found this baggie in the dryer, and that they hadn't corroborated that, so it couldn't create probable cause. That seemed to be what the trial court's determination was. Do you think a known informant, does there need to be more corroboration if they come forward and say, hey, I found this in the dryer? Is that enough for law enforcement and for ultimately for the judicial magistrate to rely on?
It's certainly information they can rely on. Now, then is the inference enough to rise to the level of probable cause?
So you're not necessarily disputing that law enforcement could rely on her statement?
Right. And I don't read Judge Strawn's opinion as stating that the officers couldn't rely on her statement. I think he was saying, you've got information here and there might be reasonable inferences, but you don't have the nexus into getting into apartment 15. And that really seemed to be where the circuit court was focusing its direction. Because if you move to the next part of the analysis, we have the claim, well, we had potentially at least methamphetamine found 5 weeks earlier. And the circuit court noted, well, maybe, but we're not sure. She's not someone that knows how to test this substance. And then I think the court also then goes in, at least we can infer the analysis. Again, that's in a communal portion of the building. This isn't something that we're saying is found right in front of apartment 15. It's apparently somewhere in the hallway. And now the circuit court didn't use this precise analysis, but when we talk about nexus, I think an important issue is also staleness. As this court is aware, under SDCL 23A 35-4, ordinarily a search warrant should be executed within 10 days. Otherwise, it starts to become stale. Now, that statute does not preclude a magistrate judge from reviewing evidence, but it gives us kind of a line in the sand, if you will. At some point, information becomes stale. If she found a baggie that she thinks might be methamphetamine sometime earlier, at some point that becomes stale. How do we tie that to apartment 15? That also then applies to the information of, well, we've got foot traffic here. The reporting witness is telling us, I've seen foot traffic, but we don't know what type. We don't know when. Was this foot traffic 3 weeks ago? Was it 2 days ago? What kind of foot traffic is it? And so that kind of gets us back into the Tenold decision, where we're talking about foot traffic alone is typically not enough to establish probable cause. Now, does that mean the court can't consider it? Well, no, it doesn't preclude consideration, but without the detailed facts in a probable cause affidavit, it leaves the circuit court in a much more difficult position.
So just, I'm sorry, forgive me, but make sure I got your argument right. So your comments at the outset and then this most recent argument make me think that it's kind of a, my word now, or sort of a house of cards argument. If the foundation of the argument, in other words, enough information to connect the probable criminal activity to apartment 15 isn't there at the outset, the rest of the distribution stuff is remote, it's stale, and is even maybe more attenuated.
Right, that would be correct. And I don't, just to make sure we're on the same page.
2 minutes, Mr. Gray.
Thank you. That is the issue, is the best evidence is obviously we have, on today's date, if we go to that date in March, we have found that bagging at field tests. Okay. If that's not enough to get us into apartment 15 because it's in the communal area, okay, well, let's look what else we have. That stuff's getting pretty old.
But when you have that immediate event coupled with the maybe undated older event, that's the key link that was missing in Tenold, correct? Because that's what got struck from the affidavit because of the unlawful stop. Here we don't have any issues with the immediate information that, you can argue about whether there was a nexus to apartment 15, but if there was a reasonable inference, we have that here. They didn't have that in the Tenold affidavit. Isn't that a key distinction?
You're right. I can't look you in the eye and say Tenold dictates that you affirm in this case. That's true. But this is different. Tenold, I don't really view that as a nexus case as much as this case, because in Tenold, it sounds like they had a pretty good idea that he was staying at the Mountain Grand, I believe, and that they had some information about that. Here, the question is, okay, what gets us into apartment 15? We found something in the communal dryer. Is that really enough of an inference? Ultimately, we've got a search warrant affidavit that I would suggest needed to have additional information. If they're doing other investigations, great. Tell the court about the facts, not merely the conclusion that we have some uncorroborated information that's going on. If there's another individual that's there, when did that happen? When he was arrested, if he showed up and he came into the apartment building and he left and he was pulled over and charged with methamphetamine, was he charged because it was in a system? Did he have a pipe? Did he have a bag? How can the court help to put that information into a context so it can say, okay, that helps to tie a nexus to apartment 15. We don't know where that methamphetamine came from or what source, or what form it was in to help us decide if it must have come from apartment 15 or when. And so I see that my time is up. I will allow Mr. Pascalucci to address the good faith issue and our request to be heard on that matter.
Thank you, Mr. Gray.
Court, and thank you for allowing us to appear in person.
Mr. Pascalucci, you have 10 minutes, sir.
Good morning, Chief Justice Gilbertson, fellow justices, counsel. Not apply to this case here today. The main reason is the first exception of the good faith, which is that the magistrate or judge in issuing a warrant was misled by information in an affidavit that the applicant knew was false or would have known was false except for his reckless disregard of the truth. The reckless disregard of the truth in this case here is that the officer that submitted the warrant did not inform the magistrate that there had been an illegal entry into the premises. I think that is key information that should have been raised, and I think because of that information that there is not an exception that would apply to allow this evidence to go forward, and under the exclusionary rule, it should be suppressed.
Does it matter whether or not information from the entry was included in the affidavit and pertinent to whether there was probable cause for it to be issued?
I'm sorry, what do you mean the information from the entry?
Well, any information that the officer obtained after the entry, I mean, was there anything about the entry that then ends up being pertinent to what is contained in the affidavit?
There was nothing per se in the affidavit relating to that, but when we go back to the perennial tenet of the Fourth Amendment that a person's house is their castle, I know it's a trite statement, but it is so true. That dwelling had the right to Fourth Amendment protection. And the U.S. Supreme Court and this Supreme Court have held previously that when that rule is violated, there has to be a deterrent. So in this case here, and cases have held that if an officer tries to go ahead and then, like in this case here, make contact with the occupant of apartment 15, he puts himself at risk for whatever happens after that point in time. He made the decision to make the contact with the person in that apartment. When he did so, at least at that point, he occupies no different position than any other citizen going to the door and knocking on the door. There's no obligation on the occupant to answer that door.
So I want to just make sure I understand your argument. Are you arguing that assuming that initial entry was illegal, that goes to the issue of good faith, or it goes to both good faith and probable cause?
It goes to good faith, because in the way I believe that the question is posed is, does the violation, if there is a violation of good faith, does it mandate the exclusion of the evidence? And we submit, yes, it does. And the reason being is because there was not enough nexus to begin with as far as the probable cause goes. And furthermore, the officer in this case created his own emergency to try and tailor this into the exigent circumstance exception to the warrant. In an exigent circumstance, for a warrantless search, you have to have both probable cause and you have to have an exigent circumstance. So the trial court found that there was not probable cause, but that court also found there was no exigent circumstance. What's key in this case here is that the person inside the dwelling, one, never knew law enforcement was there to see him. So how could he know that law enforcement was coming for him? And secondly, when the officer approached the building, approached the apartment, and announced their decision, announced that they were present, there were no noises within inside the apartment other than someone walking in the apartment. There's no sounds that would represent, like previously, scurrying about or loud noises, something to indicate that perhaps indeed there was some destruction of evidence. Again, it's not even clear whether or not at the time of the facts in this case that there was even that the baggie that was found in the dryer actually belonged to the person inside building apartment 15. This was a community building, was a community dryer, And just because that there's something in the dryer in and of itself does not mean that it belongs to the person in apartment 15.
Yeah, but the search warrant was to search apartment 15. I mean, the occupants as well, but I mean, it was primarily a search warrant to go look inside of the apartment, not necessarily go and arrest somebody or identify somebody that, you know, is identifiable or known. Am I wrong in thinking that?
I don't necessarily think you're wrong to think that based on the search warrant as it was submitted, but the issue here is, I think, had the justice known that there was what we surmise is an illegal entry, this could have been determined differently.
Well, but let me go back to your argument about exigent circumstances. I know the circuit court said there weren't exigent circumstances, but that determination was made on the scenario of when law enforcement entered the second time, wasn't it? That after the court determined there was not probable cause, the court said there wasn't exigent circumstances to go in at that point either. The court didn't make any determination on the first entry as to exigent circumstances, did it?
I believe the court ruled on the initial. The initial entry was based on when law enforcement actually went into the apartment was because they believed exigent circumstances were occurring after they knocked on the door. And in reality, they could have just gone back. If they truly believed they had all this, they could have gone back and done their search warrant based on the facts that they had it, especially given the fact that the person inside the apartment didn't know he was being looked at.
Two thoughts, I guess. One, it's not really clear to me from the affidavit that they really got any real evidence or seized any real evidence there, and that was Justice Jensen's exchange with Ms. Hankey. But more to the point, what's wrong or, you know, violates that first prong of Leon in this affidavit, the way the officer describes the entry? He doesn't purport to go in there with any authority, like a warrant or anything like that. He reports, from my reading of it, I guess what his perceptions were. And he says he went in there. I mean, it wouldn't, if you were a judge or a magistrate looking at that, wouldn't you say, well, it looks like they effected a warrantless entry into apartment 15. They're telling me about it.
But he's not painting the true picture. He's not saying that he said he went into it, but he doesn't indicate under how or under what means. For all he knows,
2 minutes, counsel.
it could have been, as so often happens, you go to the door, law enforcement goes to the door, they knock on the door, they're like, hi, can we come in? And they're in. It doesn't indicate that this, in essence, was a busting down of the door and going into someone's dwelling.
I attempted to gain entry into apartment 15 to prevent Olmsted from destroying evidence. Doesn't sound like consent.
But he says to prevent him from destroying evidence, and there's no indication that he was destroying evidence. And I think that's key too. He's manufacturing this event that there's some destruction of evidence going on. And again, Mr. Olmsted doesn't even know why police could be at that apartment, which, by the way, is not his apartment.
Well, he could be wrong about that. He could be wrong about the exigency, and he could maybe make a wrong decision about that. But does that mean he's lying about it?
Well, I don't think he conveyed the full actual case, the full facts of the entry there. I think he had time to go back and get a warrant, and to give him that warrant and allow the judge to make the decision on that case.
You say that this is not his apartment, then why is he entitled to Fourth Amendment protection?
I'm sorry, I couldn't hear the first part.
You made the comment just now that this was not his apartment.
It was not his apartment, but it was his girlfriend's apartment, and so these are co-defendants, so we're arguing on both sides of this here. But the fact of the matter is that we do not believe, besides that there is a good faith exception, we also believe that the record does not have all the facts that were determined, that could have been determined by the circuit court, and that if we want to have some additional findings, that this could in fact be remanded back to circuit court to have the court look at that and then issue findings of fact as it relates to the evaluation.
Okay, thank you, and your time has expired.
Thank you.
Ms. Handke, you have 10 minutes for rebuttal.
Thank you, Your Honor. I'm going to pick up, if that's okay, where Mr. Pascalucci left off in his conversation with Justice Salter. Law enforcement did not mislead Judge Callahan in their affidavit. Justice Salter was discussing what the affidavit said. Officer Jan put in his affidavit, I heard inside apartment 15 as if someone was walking around. Based on the items located in the dryer and the prior history possibly associated with the residence, Lieutenant Martins and I attempted to gain entry into apartment 15. There was no misleading the court. The court had the information presented, exactly as Mr. Pascalucci was saying. He heard him walking around. He was afraid they were destroying evidence, so they gained entry. I don't think the issuing judge was misled by that information in the affidavit.
Well, Ms. Hank, I want to ask you the same question I asked defense counsel. The question of exigent circumstances, the only issue that was in front of the court was the question of, was it illegal for law enforcement to enter the apartment when they had a search warrant? So they enter the apartment with the search warrant. Circuit court says there's not probable cause for that warrant. Then the circuit court addresses the state's next argument, which was, well, there were exigent circumstances to enter the apartment at that time.
Right.
Was there any determination made that initial, whether there was exigent circumstances, or is that in front of us as to that first entry?
I don't think there was a distinction made in the circuit court's findings. It says Officer Jan's warrantless search was not permissible in defendant's apartment when it was talking about the exigent circumstances. And I don't think the circuit court made a distinction of before the search warrant entry versus the second entry, Your Honor. I think he just viewed it as a whole and found there was not exigent circumstances to enter the apartment. In addition to the good faith exception, this isn't like the 10-hole case where law enforcement was actively looking for any way to get into this apartment. It kind of fell into their lap, so to speak. Investigator Olson was actively working this drug investigation, and lo and behold, Ms. Roberts finds them tied to apartment. And that kind of dovetails into my next argument, where counsel was saying there wasn't enough nexus to connect the methamphetamine in the dryer to apartment 15. Ms. Roberts went to apartment 15, knocked on the door, and asked Olmsted to remove his clothes. She went to his apartment and asked him to remove his clothes. She watched him remove his clothes, and immediately after she found methamphetamine. To say there is not a sufficient nexus there, I don't know how there can't be a sufficient nexus. We have an eyewitness who watched all of these events unfold. Not only did she watch these events unfold, but she reported them to law enforcement what she saw happen.
It's a community dryer.
It was, Your Honor. But this goes back to, we're at the probable cause stage. We're not at the beyond a reasonable doubt. That's for the trial court to hash out later. So, is there a probability, is it more probable than not, the drugs found in the dryer belong to Mr. Olmsted in apartment 15? And the answer is yes. Yes, there is a probability that those were his drugs. And going back to what Justice Devaney was talking about, we have to give this magistrate judge, we have to allow them to draw every reasonable inference possible. Reasonable inferences. Is it reasonable to think that Mr. Olmsted, after Roberts knocked on his door of apartment 15 and said, hey, can you remove your clothes? She watched him, then she finds them. Is it reasonable to assume that there are going to be drugs in apartment 15? And the answer to that question is also yes. So based on the totality of the circumstances, there was sufficient evidence in this affidavit to support the judge's probable cause. And I would
move this court that it should reverse the circuit court's finding. If there are no further questions from this court.
Okay. Thank you, Ms. Hanke. This completes our oral argument portion of our term for the week. These things just don't happen. It takes several months of planning to coordinate security, coordinate with the law school, we'll coordinate with the court, and to make it even dicier this year, we had to deal with COVID, which obviously we've never had to deal with before. It was uncertain whether this term could be held in the manner which we traditionally did, even up to several weeks before the term started. We simply didn't know, but we moved forward in the hopes that it could happen. The court would like to thank a lot of people who made this possible. President Gestring, Dean Fulton, the faculty, the staff of the law school, our security, South Dakota Highway Patrol, the campus police, the Vermilion Police Department, our student monitors, and the students themselves. We always enjoy coming down here. We hope that you students and public find this a teaching tool and that you've learned a little bit more about how our legal system functions. With that, we are in recess.